Thank you. And now for the only person who has the expertise our previous panel did not show, Mr. Smith.
Thank you, Mr. Chairman. First, I will note that you took, and thank you, Ranking Member, as well. I'm sorry. And I want to note first that I know you took some flack for having an unbalanced panel. Fred Wertheimer, who has left and is undoubtedly out issuing a press release now, has said that he's never seen such an unbalanced panel, and I just thought I'd mention that I've been on many of those in the last 4 years, usually as the minority witness. So in any case, I appreciate your having this hearing today. Whenever we get to the regulation of speech, we find that we talk immediately about constitutional issues. And in interpreting the Constitution, the Supreme Court, it's very clear, has granted quite a bit of leeway to regulating disclosure laws relating to campaigns. It has given the government quite a bit of leeway to regulate in the area of disclosure. However, as Mr. Gordon eventually conceded in the last panel, transparency is not an unequivocal good in all circumstances at all times. And in fact, the Supreme Court has never blessed everything that's labeled as campaign finance disclosure, and the Supreme Court has never blessed this particular kind of disclosure that is proposed in this draft order. Just to give a quick rundown, for example, in Thomas v. Cullins, the Supreme Court held that labor organizers don't have to identify themselves. They can do that anonymously. In Talley v. California, the Supreme Court held that picketers and boycotters, such as people who might want to boycott, say, the Koch brothers or Target, don't have to identify themselves. They can do that anonymously. In Watchtower Bible and Tract Society versus Village of Stratton, the Supreme Court said that people going door to door don't have to identify themselves, such as, for example, maybe people working for Organizing for America. They could do that anonymously. In McIntyre versus Ohio Elections Commission, the Supreme Court held directly that individuals cannot be required to report small levels of political activity to the government, which is what this draft order would require to be done through an indirect process. And of course, in NAACP versus Alabama and a series of other decisions, the Supreme Court held that membership organizations, at least those at a minimum that had legitimate fears of harassment and retaliation, could not be required to disclose their members to the government. So the Court has not, as a constitutional matter, generally approved all disclosure. When it has approved disclosure, it has done so for political committees or where there is no vagueness, that is, it has required a bright line test. It goes without saying that we're not dealing with political committees here, so the question is there a bright line? I don't think this meets this test as set forth in Buckley v. Vallejo and other cases. I won't go into the details other than to say that terms such as intention or reasonable expectation that funds you gave to somebody 2 years ago were going to be used for some type of political activity are, I think, very vague terms. Other terms that could be vague: officers, how far down does it go, subsidiaries that are under control of a company or other organizations under control of a company. Indeed, even terms such as independent expenditure and electioneering communications are malleable. That is, they have meanings for election law specialists, but it's not at all clear that they have meanings for Federal compliance officers, and I doubt that most officers working there would have expertise in that area or know the relevant judicial precedents. Further, the government has to have a compelling government interest. What is that government interest here? We've heard repeatedly that A, this information won't actually be used by the government in contracting, B, there's no problem with contracting corruption, and if there were, you should probably be issuing some subpoenas and having some investigations of the current process. We're told, it's been pointed out, that most of this activity is already disclosed. What's not disclosed are contributions by contractors that would go to a third party that might spend them for political activity, but they're not designated for political activity. We've never seen something like that required and approved by the Court before. This is what we call at the Center for Competitive Politics, which I should note I also run. We call this junk disclosure. It basically just duplicates. It requires extra forms, extra reporting. It may create different standards for different people. And indeed, there's quite a bit of growing evidence that this does not increase public confidence in government. Studies by Nate Persili of Columbia, Kelly Lamy of the University of Pennsylvania, Jeffrey Milo of the University of Missouri have shown that excessive disclosure often, in fact, decreases public confidence in government. Here you would have the presumption out there that, here's disclosure, and here, here's the contract, and people are going to draw the connection. You have to give to get the contract. What is a contractor going to think 6 years from now? Somebody who's not in business today, and he sits down to bid on his first government contract, and there he sees, who have you given your major political contributions to? So I don't see this reducing or, increasing public confidence in government. And I think we should recognize that the possibilities for retaliation that have made the Supreme Court hesitant are very real. We know of the Nixon enemies list. We know of the K Street project. We know that during the Clinton administration there was concern that trips on international business trips were being sold to donors. And the answer to that was not to require more disclosure, not to say, oh, tell us all this stuff. It was to say you cannot consider that, you cannot put that in your application. And I think that's the way that this should be dealt with here. Thank you.